Sexual Harassment in the Workplace from Baker College, a Writing 115 collaborative presentation. Narration by Nicholas Berger. What constitutes as sexual harassment? We will briefly define and state the legal precedents involved in this type of harassment. The Supreme Court defines sexual harassment as unwelcome sexual advances, requests for sexual favors, and other verbal or physical conduct of a sexual nature. It further elaborates in stating that sexual harassment occurs when such conduct has the purpose or effect of unreasonably interfering with an individual's work performance or creating an intimidating, hostile, or offensive working environment. The U.S. Equal Employment Opportunity Commission states that it is unlawful to harass a person because of that person's sex. Sexual harassment does not always have to be overtly sexual. It could simply be a pattern of behavior that seeks to upset or offend employees of a particular sex. There are two types of harassment: hostile environment and quid pro quo. Hostile environment harassment manifests itself in inappropriate, unwelcome, or offensive forms of hostility that become part of an everyday work environment. Hostile environment harassment occurs when employees of one sex are subject to insults, intimidation, crude jokes, and ridicule from members of the opposite sex. Quid pro quo harassment is more subtle and involves agreements or understandings where employees of a certain sex are made to tolerate inappropriate behavior in order to keep their working conditions favorable. Quid pro quo harassment occurs when an employer makes an evaluative decision not based on the performance or other related factors, but based on the individual's willingness to submit to inappropriate sexual conduct. Now we will touch on possible remedies and Equal Employment Opportunity Commission guidelines. What you can do if you feel you're being sexually harassed. Many times, an employee can simply register a complaint to the employer's HR department or the management, and the employer will take steps to end the harassment. This typically resolves most cases of sexual harassment, as companies seek to avoid litigation whenever possible. When an employer fails to take steps to end the harassment, a victim can file charges with the Equal Employment Opportunity Commission. Before 1991, courts could only rescind employer actions that occurred due to sexual harassment, and also award any back pay deemed necessary. After the Civil Rights ruling of 1991, courts can now award plaintiffs monetary damages for pain and suffering, referring to the psychological effects of the harassment. Finally, courts can assign punitive damages to companies with a bad reputation of harassing its employees. Thank you for listening to this presentation. This has been a production of Baker College Online.